I can.
The opening of the Oldham County Code Enforcement Board meeting for August 2, 2023. The first item on the agenda is we're going to take care of the business of the minutes. Has the board had a chance to take a look at the minutes?
Madam Chair, I'll make a motion that the minutes of the June the 7th meeting be approved as distributed.
Okay, we have a motion on the floor. Do I have a second?
I have a second.
Okay, all in favor say aye.
Aye.
Opposed, nay. Okay, the minutes have been approved. Okay,
Madam
now,
Chair, just we want to add an item to old business.
Okay, sir.
I think it should come from a vote by the board, co-board to make sure. It's 1407 Grandview Drive, and there's an update that just happened today. So
okay,
I think it would be wise to accept that as a motion to change the agenda.
okay, we have a request for a motion to change the agenda to include a new case, 1407 Grandview Drive.
So moved.
Okay, do I have a second?
Second.
All in favor say aye.
Aye.
Opposed, nay. Okay, motion carries. Thank you for your patience.
No, keep it for now.
it up by me?
Just,
Okay.
yeah, so you can.
All right. Okay, what is the first case we're listening to?
So the first case is citation number 708-11316 Deham Drive in Louisville, Kentucky. The owner on record is Ashley Hill of 8105 Braxton Road, Apartment 6 in Louisville. That is not her current address, but that is the address that we have on file through the PVA. This is the general location of the property in question. It is in Willow Creek subdivision. The violation is Oldham County Nuisance, Section 2, Duty of Maintenance of Private Property. So this case goes back to 2022. It was case number 22-0034. You all did see this last year sometime. These are some pictures that were taken back there on a complaint that I received regarding a house that had been burnt. This is the courtesy letter that was issued to the owner on record at that time. So once again, this was issued back in March of 2022. On March the 21st of 22, I did issue a notice of violation. There was no response from the owner. Obviously, she did not reside at the residence nor at the address that we had that I was mailing my information to. In May of 22, I spoke to an attorney for the mortgage holder. He informed me that he was waiting on the foreclosure and the property should be auctioned off in 2 to 3 months. So that was May of 2022. May the 26th, the company had hired a company by the name of Safeguard Code Compliance to manage and maintain the property. On August the 4th, no improvement was done, and I had sent emails to Code Compliance and left messages with the attorney and informed them that I was issuing a citation at that time. In August of 22, that citation number 674 was issued. It was sent to the owner on record, and I did email a copy to Safeguard Properties. These are some pictures of the property right at a year ago, back in August of 22. February of 22, and I'm showing just some different pictures of the property in the time frame. This citation we did dismiss. The process at the time was being foreclosed by the bank. So we dismissed that citation under the idea that the bank was going to be taking control of the property and moving forward with getting the property cleaned up. As of June the 27th of this year, no improvements have been made to the property. And the mortgage company has pulled this property from the Master Commissioner's docket several times. The property remains in violation. So on July the 6th, I did issue citation number 708, and that is the one we are here for today. From talking to the property, the Master Commissioner, it appears that this property has been pulled from the sale docket 5 different times since 22. So they put it up for auction and then pulled it 5 different times. These are some pictures taken June the 27th of 23 when I issued the citation. The first picture is, the picture on the left is of the front of the house. The picture on the right is the side of the house. You can see the tarp hanging there and the burnt part of the home. This is 2 pictures of the rear of the home. You can see there's no roof covering over it and substantial damage done to the house. The yard itself has been being cut, but the building itself and the structure is definitely been a nuisance to the neighbors. A couple more pictures from June 27th. This is on the left side of the house, and one more picture showing the front of the property with vegetation growing up on the front. I mean, it's clearly in bad shape. This is a copy of the citation that was issued on July the 6th of this year. This is a picture showing that the citation was posted on the door. I did send a copy to the owner on record, and a copy was sent to the bank that had a list pendants filed on the property. I did receive the new address for the property owner, so I actually sent it to her, and she did contact me, and I believe she is here today. On July 17th, I did receive an email from Ashley Hill. She requested an extension. I did inform her that we would not be, no extensions would be given due to the history and how long the case had been going. On July the 11th, I received an email from the law office that was representing the bank asking how to resolve the violation. I informed them that the property needs to be brought into compliance by restoration of the building or demolition of the structure and cleanup of the property. On July the 28th, the law office did respond to me with an email. I believe I gave you all copies of the email list. That their client's preservation team had indicated they have no intentions to make any repairs at this time and that they have reset the foreclosure sale. So that was just the other day. But they said they have no intentions of making any repairs. This is an email that I actually received this morning. This is from Safeguard Properties. If you want to read it or you want me to read it out loud. I'm contacting you on behalf of Safeguard Properties, who is preserving this property on behalf of an investor in above-mentioned violation case 22-0034. Can you please provide specifics on what is needed to abate the violations? We do have an open order to review and pay the citation. Bids currently being provided to clean gutters, install new tarp in the roof until the property goes through foreclosure sale. Title transfers out of the owner's name and then repairs can begin. This is the current condition as of yesterday. The front of the house, once again, the side and the back. And that's the end of my presentation at this time. I do know you have homeowners from the surrounding area here to discuss, and Ashley Hill's here and the attorneys on Zoom.
Okay. We'll proceed first with any, you have homeowners to come up first? Okay, we're going to ask you to raise your right hand. Give us your name, please.
Lisa Card.
Do you solemnly swear or affirm that the testimony you are about to give this board is true and accurate to the best of your belief and knowledge?
Yes.
Can you give us your address, please?
5505 Windy Willow Drive. So the intersection that's close to that house, I'm just on the other side of it on Windy Willow. I'm on the corner of Windy Willow and Deham. So that house has been sitting like that for so long. We are so tired of looking at it. I'm a trustee on the Willow Creek Neighborhood Association, and it's just time. You know, they've pulled it 5 times. How many chances do they get, guys? You know, they have had plenty of chances to do the right thing and take care of business, and they haven't. So we're just asking you as a neighborhood to please step up and push this along, because something needs to happen. The kids get in there, it's dangerous. And this isn't the first time I've spoken about this with you all. I was here last summer. I think it was after the waste transfer station. So we're just asking you guys to please, I mean, I know if you all had started, we didn't even know that you all didn't know about this until like 2 years into it. And then there was trouble finding the fire department report, because I think that's when all the fire departments got kind of mixed up and changed names and so forth. So it's been a long road, and we just really want it taken care of. So,
Thank
do you have
very
any
much.
questions for me? Okay, all right, thank you.
Thank you. Is there anyone else here to speak at this time? No? No, they're up. Okay. All right, and you said we have the owner here? And that is Ashley?
Ashley Hill is here. Yeah, she's here.
Okay, would she like to come forward, please? Okay, can you hear what's going on? Okay, good, thank you. Okay, I need you to raise your right hand, please. All right, Ashley, can you give us your home address?
My current
Your
address.
current address.
111 East Constant Street, North Carolina, Columbus, North Carolina, 28722.
Thank you. And you're the current owner, is that correct?
Still am, yes.
Okay, and go ahead and give your side of the story.
I
You want
agree
me to
with the
swear her in?
neighbors.
Oh, I'm sorry. I got a little ahead of myself. Please swear her in.
Raise your right hand. Do you solemnly swear or affirm that the testimony you are about to give this board is true and accurate to the best of your belief and knowledge?
I do.
Thank you.
Okay, so I have brought in a stack of emails from both Amera Home, which is the mortgage company, and their lawyer's office, as well as some phone records for the past 2 years. I actually have written phone records from 2 years prior to that of this runaround that I have personally been trying to deal with the mortgage company to release the funds from the insurance company so that someone can either demolish or fix the home. This home, I have not made a payment on since 2019. I was told it was going to foreclosure. I have lost all physical access. I am not able to enter the property, and it has changed over to their holding company, they told me. I had to go to court in 2019 just to get a 24-hour access to try to get anything that was salvageable, but then I was told lockbox would be changed and that I needed to stay off the property until this was handled. But meanwhile, I've been sitting here trying to figure out what I need to do as still the owner, why this hasn't been fixed. I have released the money for the insurance. It's not in my name. The entire check was written over to Amera Home. They have it sitting in a escrow account from what they've told me. And I finally spoke to someone who said they could release the funds for me to hire a contractor, but they told me I had to contact the lawyer's office to get access to the property. When I contacted the lawyer's office, they told me I had to talk to property preservation at AmeriHome, which is the exact people that sent me to the lawyer's office. And it's just been like this for the last couple years when I am able to get a hold of somebody. It feels like I'm running through loops and I'm getting stonewalled. I don't know what I'm supposed to be doing or what I can be doing because I keep being told, well, it's on sale for mortgage, it's gonna be taken care of. So I sit back, and then I got a letter this time for this code violation, but that's the first violation that I had heard of. So I brought what I could. I do have more handwritten notes. I just got what I was able to print off my computer here today. So I can pass this up to somebody if you want to go through it, or if it doesn't matter.
Do we want these copies? Okay, can you put them on the projector? Can you show how to do it?
Do I just lay it face down on the screen?
Adam's going to help you with that, or somebody.
Okay, so we've got. Okay, so I have 3 pages of these. This phone number is AmeriHome's phone number, and these are the dates, the contact dates. I have 3 pages that are all similar. Almost all of these phone calls were where either they would call me, I would answer the phone, they would ask me to make a payment on my mortgage. I would say, hey, this is what's going on. And they'd go, oh, we need to transfer you. And 9 times out of 10, the phone call would get disconnected.
Move toward the mic.
Oh, I'm sorry. It would get disconnected if,
This way you can come over.
okay. When I did call through, I would often get transferred around to different departments and then was told that someone would call me back. A few times I was able to speak to someone, and one time I was able to speak to property preservation, which is who gave me the check number and the check date for what Farm Bureau had released. So that was the first piece of information I found, and that took me till last year when I finally found that. Going forward with that, I was told I would need to contact the mortgage company to see about how to release the funds because the check was in the mortgage company's name, not in my name, which she said was rare. So she said that happened if the property was being foreclosed on, which I knew it was. I couldn't get anybody. I finally did speak to a Tracy Fain, which there's just 3 pages of this, but then this is the email from Tracy Fain, where we went back and forth of her asking, did I want to use the money to pay the property off, or did I want to do repairs? Right now, that property, they're charging me almost $100,000 more than what my original loan was for, and it's way more than what the bank had paid or the insurance company had paid anyway. I explained to them that's not what I wanted to do, that if we were going to go forward, I would want them to repair the home. I then asked them right here about how to start repairs. This is the email where they've told me that I need to hire a contractor and that I would need to hire my own contractor to contact the insurance company. But the insurance company isn't having anything to do with it because they've already released the funds. So that's kind of the runaround of me finally being told that I had to contact the lawyer's office in order to get access to the property. I have a few more emails from Tracy Fain, but they're all just back and forth on trying to deal with this property and how to release the funds. And then this one is from the attorney. The bottom part is where is the email that she sent me. The top part is my response after that, where I am explaining to her that I feel like I'm running in circles because the bottom part is where she's telling me that she's the foreclosure attorney and that I need to contact the property preservation team, which is the exact team that gave me their phone number and name. And I'm sure it was on accident, but they gave me the wrong phone number. So it took me a lot of searching to finally find an email and their proper phone number to get someone to contact me back on this one. So they've all been responding to me, but I feel like they're just responding to me to go back to, it's like a kid going back and forth between their mom and their dad, go ask mom, go ask dad. That's what this feels like, because I can't get a clear answer of what I can do or what I should do, or if I just need to wait for this foreclosure to go through. But this happened in 2019. I have never heard of anything taking so long, and my mom is a real estate agent. So to me, it's just like, I don't know what is taking so long. But if I had to live next to this house, I would be upset too. So if you guys can tell me what to do or what I should do, I will go that path as well. But I'm kind of at a loss for what I can do to make the people in charge either let me on the property and give me the money to start the repairs, or to go ahead and take the property and start their foreclosure. Because I feel like I've been told this house was going into foreclosure multiple times, and I guess this is the first time I'm hearing that they had pulled it 5 times. But that's about how many times I have contacted and been told, oh, it's on the bid for foreclosure. It's on the bid for foreclosure. I just assumed it was never bought. They haven't really given me much information. So
Thank you, Ashley. We'll ask you to sit down for just a few minutes, please.
thank you.
Okay, so is there anyone else who wants to speak on behalf or against this? Okay, seeing none. Okay. Would you like to speak?
This is a little different. We've
It's a
got
little
a person
awkward,
on
but we'll figure
Zoom
it
and we're
out.
not set up, so we're going to try to, you won't be able to see who the person, but
Okay, would you first give us your name?
Cindy, put your microphone down there too. Just try the best we can. I don't know.
Okay, that's fine.
Catherine Carpenter, and I am the attorney for Amerihome Mortgage, who is currently foreclosing.
You really
on this
can't hear
property.
her.
Hang
Hang on a second.
Oh, just a
Hang on.
moment, Catherine.
We really can't hear you. It's, well, I don't know, but the volume is up as high as it's going to go. And I guess it's down here. Is that it?
Okay. Catherine, if you'll be patient with us for just a moment, we're going to run and get some speakers.
Yeah, let's just take a
Okay, we're going to take a 5-minute break. Would that work for you, Catherine? We're going to try to get some speakers set up for you. We're not getting any audio.
Is this any better? Better?
Check 1, 2.
Check 1, 2.
Okay.
back
You and
here.
I can hear her.
Yeah, we're hearing her a little bit. Can you turn it up?
This is as good as it's going to get. But I'll bring her up a little bit. Okay, you can go into session.
Okay, Catherine, please proceed.
Thank you all for letting me appear by Zoom. I know it's kind of unusual, so I appreciate that.
No. Okay. Okay, Catherine, hold up for just a minute. We're going to get another speaker.
Okay,
Sorry.
no problem.
Your patience is wonderful. Thank you.
You letting me appear by Zoom is wonderful, so
you say check 1, 2?
Check 1, 2.
We can't hear it out here, Jay. Getting feedback out here, Jay. All right, let her count to 10.
Count to 10.
Count to 10.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
Jay, let me just plug the speakers in. Okay.
Great. Check 1, 2. Check 1, 2. Appreciate everyone letting me appear by Zoom, and I am sorry for creating technical difficulties for y'all. So I am the attorney representing the mortgage company in the foreclosure action. Ms. Hill has been in contact with our office in various points in time. We unfortunately do not handle this kind of sort of thing for our clients. We are just handling the foreclosure action, which I do understand the frustration with the sales being pulled multiple times. Unfortunately, that was beyond my office's control. It was instructions from AmeriHome. However, we do have this with the master commissioner to be set for a foreclosure sale again. I do not have an actual sale date yet, but we are in the process of moving this towards sale. As Mr. Bayer stated, AmeriHome does not intend to make any repairs to the property themselves until this goes through foreclosure sale. If they take it back into their real estate owned, at that point, they would obviously look into making the repairs and getting this property marketable. But outside of that, AmeriHome is not making the repairs. That would be coordinated through Ms. Hill, working directly with AmeriHome to get those funds. Even then, this loan is in default since 2019, and my client would still be foreclosing unless the mortgage is brought current. And that's pretty much it from AmeriHome's perspective.
Okay. All right. So does the owner get to do that? Okay. Okay, does anyone want to rebuttal or have? Oh. Sorry. Ashley, do you have anything you want to say in rebuttal? And please don't knock the computer off.
Sorry.
Don't knock the computer off.
No, I do agree. This is what I have been told. But again, I have talked to AmeriHome directly through Miss Faines who's a loan specialist, I believe, at AmeriHome. And she has been telling me that property preservation is the only way we can get the money released. And property preservation is still telling me that I have to go through the attorney. So I understand where the attorney's point of view is coming through. I just feel like I'm not being given the full answer from everybody. I have no ability to start any repairs because I don't have access to any funds and I don't have access to this property. So that would be my only rebuttal is I agree, but the information that I am given directly from property preservation is that they can't get me on the property, only their attorney's office can, and they gave me the Reamer Law as their attorney's office. So that would just be what I
Okay.
have. Thank you.
Thank you very much. Catherine, do you have anything you want to say to that?
I have been in touch with some more escalated contacts at AmeriHome, and the last that I heard was that they had been in contact with Ms. Hill to get access to the property. I understand we're both giving different answers and it's frustrating, but to the extent that my office can, we have been trying to facilitate our client working with her to get access.
Okay. Okay, are there any, at this point in time, I'm going to open up for board member questions? Oh, yes, I'm sorry. You have something to say? Okay. Not a board member. Okay.
So I'm not sure if it was in some of the emails that I sent you. I do want the board to understand that it was about 2 months ago. And Katie, I'm not sure if it was you that I spoke to, but I thought that it was. I spoke to one of the attorneys for the bank, and I informed them at that time, because at that time it was listed for sale again. And I told them, look, she needed to, the attorney for the bank, I informed her that she needed to let the bank know that if they pulled it again, they would be issued a citation and we would move forward with it. And if it was you, Katie, I did talk to her later. She said they did inform them of that. The attorney for the bank said that they did, tell the bank that, and the bank still pulled it once again. And so the bank does understand that from code enforcement, they've already been warned once before. If they pulled this, I was going to move forward with citations, and we were going to do everything we could to get this resolved.
And Adam, when you say pulled it, you mean pull it from the foreclosure procedure?
Correct. I think the last time they pulled it, and I don't want to say exactly the way it went down because I don't understand it all, but it went.
Then don't.
They used some
Don't.
kind of a FEMA.
Don't, if you don't understand it, don't.
Yeah.
Yeah.
Okay, I'm going to open this up right now for board member questions.
Madam Chair, I have some
Yes, sir.
questions. For the attorney, for the bank, you said it was outside of your control that these were pulled. Can you give us some color to that? Find out why?
So some of it, like I said, I'm the attorney. I take the instructions from Amera Home. They tell us to pull, we basically pull. Some of them were due to the state of the property and them reviewing internally for options for how they wanted to proceed. The most recent sale that got canceled was due to a FEMA hold, which sometimes crop up on our files as a result of, bad storms and stuff that go through areas. They will put them on hold for FEMA declarations. Apparently, this was subject to one of those, and that is why that last sale got pulled. Our client was warned by Emily in our office, was the attorney handling at that time. She did let the client know that, these code violations would be going forward if the sale was pulled again. And they still pulled because it was basically a government mandated hold. Now that has been lifted and we are proceeding to sale again.
I have another question. Has the bank, your client, directed this management company to work with Ms. Hill to resolve the violations? There's money sitting in a bank account somewhere, surely.
Yes.
Is there? Have they directed them to do that? Because it seems like that isn't necessarily filtering through.
I am unfortunately not able to speak to that issue. The last information I got was just that they had been in contact with Ms. Hill. I do not know the full substance of that, or if they have given her contact information at, I believe it's either Safeguard or Five Brothers that is, it seems like Safeguard based on the emails you guys have, that is doing the property preservation at this time.
Is there any way we can get that direction from your client so that Ms. Hill can be working in the meantime?
I have been trying to, however, as I stated earlier, this loan is still severely delinquent and in foreclosure status.
So they don't want her working with them to resolve the issue if it's in foreclosure?
From my client's perspective, it would not resolve the foreclosure issue and the fact that this is going to a master commissioner's sale.
It would help.
That's still in the background.
But would it help the property value if they were able to repair the building?
I obviously would assume that a habitable building would sell for more. However, that is unfortunately not something that the clients I have typically seen do. And my client has stated that they personally will not be undertaking the repairs.
Well, they wouldn't. Ms. Hill would, working through the property manager.
I'm going to pursue it from a different angle.
Okay.
What I'm hearing you say is that the property is already in foreclosure, how much, do you know how much money it would take? And would the owner be able to pull that up in order to then get the money to fix the house?
I do not have an exact amount of the delinquency right now. We do have a foreclosure judgment in place. This loan has been in default since 2019, so it would be a fairly substantial amount to reinstate the loan at this point and get it out of foreclosure.
Okay.
When was the foreclosure started?
It is a 2019 filing.
So it's, and did the fire happen in 19? So, what, yeah, I guess she is in delinquency, but it's as if she's got her hands tied because she's not going to make payments on the property for 4 years there where somebody else has got the money. So to say that she's as delinquent as she is, I think is a misrepresentation.
Well, but someone else had the money that was to be used to repair the property.
Right.
Was not meant just to be making house payments.
Correct.
So that 140,000 wasn't just to make house payments.
Correct.
It was to make the repairs. So she didn't make the house payments.
Right.
So we have a double whammy going on here.
The other question I have is, why was the property pulled? She just went off Zoom. Why
I
was
lost
the?
her.
It says this free meeting has ended.
Well, the last one was because of FEMA.
Right, FEMA, but the.
And what the 4 times before, who knows?
Yeah.
But does that matter to us?
Doesn't matter.
So I've heard that, I thought I heard an attorney say that it's been foreclosed,
No, she said.
No, it's been in the process.
still in the process of being foreclosed.
Okay. Okay.
The phone now. Okay. I apologize for that.
Oh, that's quite all
Go back
right.
on.
Is there any other
Why,
discussions?
and I guess my question, sorry for the interruption, is the previous times, not this last time, but the previous 3 or 4 times when the property was offered for foreclosure and then was canceled, what was the reason for canceling at that time?
Without reading through my entire file, I can't speak as to every single one of those cancellations, but at least one of those was related to an internal review at the client for potentially writing off the loan or valuation to see if it was worth proceeding with. And then they eventually decided that it was, they did want to continue with the foreclosure.
When was the first sale that was canceled?
It was quite a while ago, I believe. I am looking that up in a minute. See if I can find it in my file. There is a lot. Getting there. I apologize, I should have had this open sooner. Let me try that. Yeah. So our judgment in this matter was entered in May of 2021. And then there have been sales set at various times since then. It looks like the first one was set for June 29th of 2021.
Are there any other questions of the board members?
I guess I just have one more, Madam Chair. Is Miss Hill still the owner of record of this property?
Yes.
Can she sell this property?
You could. It would require a full payoff. I'm not sure what that balance is right now, but.
I don't know how you'd sell it if you can't access it, which is why I asked the question that I asked as to who the owner is, because if I'm an owner, I enjoy the rights and privileges of accessing the property.
I understand, and I've been working my side to try and get access, but I unfortunately sometimes, even as their counsel, encounter the same issues that the borrowers do.
When was the last time she had access to it?
I am not sure. I do know that our office was able to get her access at some point to remove some personal belongings. I don't know when that date was. Ms. Hill could speak to that.
Okay, if we're finished with the board questions, I would like us to get back to what we needed to, and our intent here was to go through a nuisance complaint and to find out if we have one here. So I would like us to start the procedure, the suggested motions, the whole procedure for us to go through, because we recognize, hearing from the community, that we do have issues with this property. So who would like to start with the procedural matters?
Madam Chair, I'd like to move that the citation was issued properly on July 6, 2023, to the owner of the property, and that the property is in violation of Oldham County Ordinance KOC 89-800-846, Section 1, that the premises is detrimental to the property of others, or causes or tends to cause substantial diminution to the value of other properties in the community, and that the violation was observed by the officer on June 27, 2023.
Okay, we have a
And that's
motion
that motion.
on the floor for procedure matters. Do I have a second?
A second.
All in favor, say aye.
Aye.
Okay. On to the nuisance ordinance. Violation? Oh, you did both? You did both? Okay. Okay, I was still on procedure. Okay. Okay, we have determination of penalty. Do you have a board member who would like to work with the final order?
Do we need to discuss what potential order, remediation that would be? Because it seems to me that our only next recourse, is to go the lien route and refer to the fiscal court. Well, discussion on that matter. It seems to me that's our only recourse.
I think it's the only recourse in most of these cases. If the condition remains, then the next step would be to issue additional citations, and if they're not paid, they're made into liens, and the liens are foreclosed on. It's practically the same process that the mortgage company's going through. We would not have the same requirements to do internal reviews and pull for federal mandates and those kind of things.
Just to be clear, Matt, the sending it to fiscal court only happens if the citations aren't paid.
Yes. But that would be the motion. I'm assuming that we would, the citation needs to be paid, and that if it's not remedied, that additional citations will be issued.
Yeah, it's an interesting situation because the foreclosure by fiscal court would not be possible unless there are unpaid citations. So if a property owner just paid the citations, or somebody else, like a third party, perhaps like a mortgage company, paid the citations on behalf of the homeowner, that would frustrate fiscal court's ability to foreclose on the property. That's why a year ago, it was my recommendation that we not get in the way of the mortgage company and let them proceed and get to a judgment and a sale, because that would be the most efficient way to achieve new ownership and a correction of the problem. For whatever reason, that just didn't happen. So, but the reality is that if somebody pays the citation, then we would be right back where we started.
Is your recommendation the same now as it was in the previous case?
Well, I don't think there's any problem with Adam issuing citations. If they're not paid, we can put liens against the property and at least be in a position to do something if the time comes.
Matt, is in the remedial order, if the board, I guess in the remedial order said that the bank should pursue foreclosure, and then they didn't for some reason, it was pulled again, could the board establish a much higher fine?
I think the board would be limited to what the ordinance allows. And I think it's questionable that the board would have the authority to order anybody to do anything. That's in the nature of injunctive relief, which can't even be ordered by a district judge. It has to come from a circuit judge. So the board's hands are tied in terms of actually forcing anything here. and it's not unique. I mean, that's just the situation for all of these properties that need to be fixed up. It's usually a financial interest for the homeowners to avoid daily fines and liens against their property. In this case, I don't know that the homeowner would have the same interest as an owner who lived in the property or necessarily cared about the condition of it.
I think what the difficulty is this has been going on a long time, and you heard testimony from HOA representative who, and Adam has heard this multiple times, there's a frustration that this, in the meantime, after all this posturing or whatever else, which I'm going to say we don't actually care about, who is going to either sell or fix the building? And how do we get to some point where we can say it's somebody's responsibility when Ms. Hill says is the owner of record, but doesn't even have a right to get on the property somehow? And the bank is saying, we've got emails where they said they weren't going to fix it. Whose responsibility and when? And Catherine, I'm speaking to you. This is frustrating. And it's not just frustrating from a code enforcement perspective. We're the ones who get looked at like we're not doing anything. The HOA person wasn't frustrated with Ms. Hill or with you. She was frustrated with the county because we haven't gotten anything done.
I certainly understand your frustrations. I get it. Nobody wants the house that looks like that in their neighborhood. The best I can give you, and I know it's basically an empty promise, but the way this case has gone is that we are moving towards a foreclosure sale to get this into new ownership.
Has that date has not been set yet, right?
What's that?
That date has not been set yet.
Right. You know, our other course of action, I'm just, by introduction, Jim Urban, I'm the Director of Planning and Development Services. Our other course of action is to go to fiscal court and declare this building dilapidated, and then we can force a demolition. And for at least a year now, I've been saying we should do that, get that process going and do it, in which case we have the right to be able to go in there and demolish it. And that would get rid of the eyesore. And that wouldn't solve a problem for either Miss Hill or for the bank, because now the property would be, well, it wouldn't have any usable building on it. And I'm going to suggest that the code board instruct staff to go ahead and start that process through fiscal court. You got to understand, this has gone on way too long, with too many excuses or reasons, whether they're legitimate or not, and everybody else has to deal with it. And so if the board is so inclined, that's one of the things we can do, is we'll take it through the dilapidated structure process, and fiscal court can order it torn down.
How long would that take?
About a 3-month process.
And would that cost go on as a lien on the property?
Yes.
I move to do that. That's my motion.
Okay, we have a motion on the floor to have the code enforcement office to move this property to the dilapidated process?
Well,
Is that what you're saying?
I'm going to pause this for just a second,
Okay.
because you still have to deal with the issue of the rest of your stuff, the civil
Yes.
fine
Yes.
and that first, and establish
Okay.
what the remedial order is. After that, you can add, let's go through the dilapidated structure. Matt, is that reasonable?
I think that's probably best. There needs to be a determination of what the penalty is for this violation. I believe the board's already voted that there is a violation.
Violation.
Madam Chair, I'll make a motion that the citation stand, and that the fine associated with that citation be reduced to 0. Can that be done?
I think the ordinance is pretty specific about what the fine will be. I think the only movement in that is, was it contested or was it uncontested? And are there previous findings of violation of the same ordinance? I don't think I guess the board could could do it, and if nobody appeals it, then it stands, but I'm not sure that that would achieve our objective today.
Do you want to restate your motion?
Well, I don't know if that's necessary at this point after, with his advice.
Well, I think let's be clear. We got to rescind. There's a motion on one side, a motion on the other side. We got two motions, no seconds, and are we going to wipe those
I'll
off?
rescind my motion.
I rescind my motion.
Okay. Why don't you can you give us clear direction?
Okay.
Does anybody have a copy of the ordinance with them? Or the fine schedule, I guess, is more particular. Isn't there a specific fine that the ordinance?
The fine schedule is $150 for the first citation, $250 for a second citation, and $400 for every additional citation after that.
How frequent can you give those?
Daily.
Then I move that the 150 violations stand and that you move forward with the daily citations until the issue is resolved.
That's gonna hold her responsible.
You want to ask for seconds on that?
Do I have a second? Okay, we have no second. Okay. We do not have a second.
Okay, I think it's important that we limit the motions to very discrete things. We need to determine what the penalty is for this citation, and then if there's a separate motion for other things, we could take those up at a different time later.
Okay, I'll amend my motion that we're uphold the citation in the amount of $150 due to the following factors: previous multiple violation, and the officer observing the offense or the violation. It was permitted to exist based on substantial evidence in the record as a whole.
Okay. We have a motion on the floor. Do I have a second? No second.
I guess somebody else is going to have to try a motion if you don't.
Yep. Somebody else has to give me a motion.
I'll make a motion that a final order be made that the fine to be paid $150 for the first citation within 14 days. And if not paid, subsequent citations be issued on a monthly basis based on our established schedule for citations, $250 for the second, $400 for the third, and those thereafter.
Okay. We have a motion on the floor. Do I have a second? Okay. We have no motion.
Well, is there a compromise here somewhere?
My only issue is with the monthly, because you said the same thing I said.
You said
Can't take a 5-minute recess, can I?
that's too much work on Adam. To issue a citation every day.
Can I take a 5-minute recess?
Well, we're going to lose her
Yeah, we are.
again in 10 minutes.
Okay, I'm looking for a new motion.
Well, I needed to ask, the question is, as far as the two motions that have been made, is the frequency at which the citation should be entered or be issued. And so I wanted to ask the issuing officer what would be reasonable without causing too much work on him.
Well, it's not about the work, it's solving the problem.
It's about solving the problem.
But my stance on this is we voted there is a violation. I don't anticipate the homeowner will be inclined to pay the violation. What my intent on this is, it is our own, as far as I know, it's our only recourse, considering that the civil fine is what would start a process of potential foreclosure. And I'm holding the second motion of wanting to go through the second. I want to move somewhere. I want it to go somewhere. I don't want it to, us to say that that's going to be the issue and have that go away. Because to me, we take this issue and we put it on someone else's doorstep, and I don't want to do that.
Well, is it,
There is a citation pending.
yeah.
And
Is it,
pending.
is it reasonable to say that you want that, the current citation paid, and I'll say immediately, within whatever, 5 days? And get through this, and then instruct staff to go to fiscal court and start the dilapidated structure and condemnation process? I mean, would that resolve your kind of stalemate on making a motion in a second and getting a vote?
Is it appropriate for us to have discussion right now?
That's what we're doing.
Okay.
We're doing it.
All right. Then, my problem is if the mortgage company and the bank wouldn't have closed on all this, and we wouldn't, and this woman, we're holding Ms. Hill responsible for paying these fines. And if the mortgage company and the banks would have held up their end of the bargain, we wouldn't even be here today. So that's why I tried to make the motion that I made earlier, was that there be no monetary penalty associated with it.
But I think in reality, we have to go with the fine to the owner of the property. And I understand in another sense, we don't want to do that, but we have to, because she can work that out with the bank.
Okay.
That's not us.
Yeah, I would say, Ms. Hill, I don't want to fine you at all, but I can't fine them.
Yeah.
I want to fine them, but they aren't the owner of record. So hopefully that gives you some comfort that, I can't have something go for a year and not do something. I can't stand by that.
So let's try this again. Do we have a motion?
I make a motion that owner be required to pay the $150 fine within 5 days.
Second.
Okay. We have a motion on the floor. We have a second. All in favor say aye. Aye.
Aye.
Okay, motion carries. On to
Remedial.
the remedial order.
I move that this board recommend that the planning and zoning employees take this matter with fiscal court to start the dilapidated building process.
Second.
Okay, I have a second. Can I ask for just a little more clarification on that? When?
As soon as possible.
After the 5 days?
Well, no,
As
it
soon as
depends
possible?
on the schedule of fiscal court,
Okay.
and we have requirements in that dilapidated ordinance, and we'll just abide by that.
Okay.
I can't recite it to you exactly, but we have to give notice, and there's a number of things. That's why when I was asked, how long does it take? About 3 months in total, because, again, the fiscal court meets on a certain schedule. We have to advertise, there are certain steps we have to take. So we'll get going on it immediately.
Okay, we have a motion on the floor. Did I have a second?
Second.
Okay, we have a second. All in favor say aye.
Aye.
Opposed, nay. The motion carries. Thank you. Okay, we're going to wrap up this one.
Well, now, let me just,
Go ahead.
for Ms. Carpenter's benefit, move towards for the foreclosure. If that's what you got to do, get it done and get this property fixed up, and then, but we're going to start this procedure. And if we get ahead of you, we're going full speed.
I understand, and I will relay the message to my client as well.
Okay, thank you.
Thank you for your time.
Thank you.
Thank you.
All right, that completes this citation. Thank you very much, and Adam will get with you some information at another time.
All right, thank you so much.
Yes, we will. Okay. Okay, we're gonna just take Adam, we're gonna take the Hawthorne, we're gonna move that up on the agenda.
Just to the old business?
We're gonna do 3505 Hawthorne Court.
Okay,
Here, there's
okay.
no reason to hold him. So he's gonna be, Jim will be back in just a moment. We'll wait for Jim.
Oh, we're waiting for Jim?
Oh, yeah.
Okay.
No, I asked him not to. No, he's not.
I'll go ahead and get it.
Which one is it?
It's
This
down
is
in
under
old
This
business.
is under old business, and so it's not,
Oh, I got you.
3505.
it's one of the cases you all saw 2 months ago.
Okay, all right.
He did, but he told me today he was not going to recuse himself.
Yeah, he told me that too.
Oh, was this the
The
one?
rest of these should go pretty quick.
Okay. Right, sir?
Okay, so this is a update on a case that you all heard in June. It's case number 23-0083, 3505 Hawthorne Court. You all did issue a final order on this property. The vegetation was to be cut back and debris, trash were to be removed from the property within 30 days of June the 7th. And all the vehicles were to be removed from the property within 60 days from June the 7th. So the timeline for the vegetation to be cut back has expired. That 30 days did expire around July the 7th. The vehicles being moved from the property has not expired, but I wanted to give you all an update on where the property stands due to the fact that a portion of the final order has expired. If you look at the picture right here on the right, this is a picture from the front of the house. I do apologize, I don't have some of the older pictures. This picture is a vast improvement over the condition of the vegetation, just looking at the property from the street, from the curb of the road. This is a vehicle looking down. You can still see the junk and debris is still on the property, along with one of the vehicles that was in violation. This is the bamboo that has created an issue for the neighbors and is quite overgrown. Obviously, none of this vegetation has been removed yet. So as far as the vegetation being removed from the property, the house is still in violation. There's still quite a bit of the bamboo that needs to be removed. I do know he's here today to ask for some extensions on some things. He did get most of it away from the front of the house, but the bamboo has created an issue. It's actually growing onto the neighbor's property up against their foundation. So it's definitely an issue. And I do know he's here to talk to you all about getting that removed. As far as the vehicles go, again, I'm going to let him discuss a timeline on the removal of that, along with the removal of the trash and debris. The vehicles are in better shape, but they are still in violation. And I have discussed with him, what needs to be done for those vehicles not to be in violation. And if he wants to come up and talk and kind of tell you his ideal.
Okay, and can you tell us how much time was left on the 60 days?
So the 60 days would expire in about 4 to 5 days,
Okay,
and that would be the vehicle part.
okay,
The vegetation has already expired, and it is not done at this point in time.
okay. Thank you. All right, ma'am. You want me to let him come up and you have to swear him in? Would you like to come up, sir? And raise your right hand, please.
Do you solemnly swear or affirm that the testimony you are about to give this board is true and accurate to the best of your belief and knowledge?
I do.
Thank you.
The first thing I'd like to ask is that you remember and emphasize the phrase vast improvement that he started out with. There is a lot to do, and I have gotten a good bit done. As far as the cars, I have caught up with the taxes and the registrations. They are registered now. And I'm still in the process of getting them moving. I've got battery chargers on a couple of them. I'm more likely going to have to buy a battery or two. But they should be washed up and running by the end of this week. And 2 of them are going to be put up for sale. I'm not sure about the van that's in that picture, but it's running now and licensed, registered. So that's going to be a question of washing it and making it more presentable. And I think Adam indicated that that would be acceptable for that part of the car problem. As far as the junk at the lower part of the driveway that you could see behind the Jetta, my plan and my hope is that when the cars have been moved out of the way, I'll be able to contact Hedges or someplace else and have a small dumpster put on the driveway and get that stuff just all cleaned up in one fell swoop. And as far as the working on the bamboo in my neighbor's yard, I have already arranged with a guy who does yard work to come help me either Friday or Saturday. And our plan, it's not feasible, I think, for me to get all of the bamboo removed. That would be an enormous undertaking. But the first part of it is going to be to clear a 10-foot wide path adjacent to my neighbor's fence to keep the ingress into her yard in check. And we're hopeful that we'll be able to do a very large part of that this weekend. But I don't think it's realistic to think I can get it all done. So I'm going to ask for another extension on that. I'd be very happy if you could give me 3 weeks on the cars and maybe a month on the bamboo and the remaining vegetation.
How much is it going to take, how long is it going to take from your fence to your neighbor's house?
From the fence
Because you've got to get that out too, right? Because you said it's,
I'm not sure exactly how far it is. I don't think it may be, I don't know, it may be 8 or 10 feet.
you're already in her foundation, correct? Did I hear that correctly? In her foundation? It's attached to her foundation?
Well, I don't know exactly what the situation is in her yard. I haven't gone into her yard. And I don't know exactly how the foundation lines up with the fence between our properties.
Okay.
But the act of clearing the path along her fence line will stop
From going forward.
Stop the bamboo from trying to encroach into her yard.
Okay. Do you think you can get everything done in 2 weeks?
I think I can make very big progress on the bamboo against her fence, and I think I can get the cars moved and the dumpster in place in 2 weeks. I'd rather have 3, honest to goodness, but I'll be grateful for 2.
Madam Chair, can I ask a question?
Please.
When you were here last, we had the discussion of how long it would take to get it cleared out and cars removed. Did we not give you enough time?
Yes, you did give me enough time. I just haven't been able to get it done in that time.
So do we have a reason to believe that this next time that is going to be enough time?
I honestly made a mistake about when this hearing was going to be. I thought it was going to be the middle of next week. And I didn't have any worries about getting it completed by then.
'Cause I seem to recall you said you had a guy that was coming out that was going to do all the artwork.
He came out for one stretch, and the first time I was here in June, you saw photographs of a couple of big trees that had dead trees that had fallen. When he came out, that's pretty much all he did, was cutting up and removing all the downed wood. And he's the same fellow I'm having out either Friday or Saturday this week to work on the bamboo.
Any other questions? Can we come to a consensus? I made a recommendation.
I recommend we give him an extension of, I'll make a motion or recommend that we give him an additional 3 weeks to complete it, and if not done within 3 weeks, consider giving another citation.
Thank you.
Okay, we have a motion on the floor. Do we have a second?
I'll second this motion.
All in favor, say aye.
Aye.
Aye. Okay, motion carried.
Did you vote?
I did
you vote?
not.
So, he didn't vote.
I'm sorry?
You always,
I do it too fast.
yes, because there's somebody that may have not voted in favor of the motion.
Most of the time I catch
All those
it.
in favor say aye, all those opposed,
Say nay.
are you opposed to the motion?
Yes, sir.
Okay,
Just for the record.
thank you. Motion still carried.
I'm sorry, I didn't hear you.
Motion carried. You have 3 weeks.
Thank you very much.
And you understand you're going to get a citation if it's not done.
I do understand that.
We don't want to see you up here anymore. We want to see you get it done.
Well, I might swing by to thank you again in 3 weeks, but you won't see me.
You get it done before 3 weeks, please come.
I'll do it.
All right. Thank you
Is that
very
it?
much.
Thank you very much. Adam, thank you.
Back to the agenda.
Back to the agenda. I'm lost. Give me just a second. 7:01. All right.
701.
So this is citation number 701, 1106 Joyce Court in Crestwood, Kentucky. The owner on record was an Anthony Seidler at 6813 West Highway 146. This hearing was not requested. This is the general location of the property. It is in one of the subdivisions off Moody Lane. I apologize. Huh? Lakewood Valley, yes. This is a violation of the Oldham County Nuisance Ordinance, Section 1. This is a picture. The picture on the left is a pile of junk and debris on the left side of the house. It has been there for quite a while. And the grass height, even though I know you can't see it in the picture, it was actually quite high, especially the trimming around the trees and around the side of the house. The vegetation was overgrown. I did issue a notice of violation on May the 26th. On June the 14th, I did a drive-by, and once again, the junk and debris had not been moved. And this is a little bit better picture of the vegetation, and the vegetation was still in need of being trimmed. I issued the citation number 701 on 6/16 of 23. It was mailed by certified mail to the owner on record. He did receive it and sign for it, and a copy was also posted on the door on June the 16th. As of after issuing the citation on July 10th, the grass and vegetation was cut and trimmed, and the junk and debris had all been picked up and cleaned. So this is a case summary and history. On 5/24, the property was found to be in violation. On the 26th, the NOV was issued. On June the 14th, a follow-up showed that the junk, debris, and vegetation remained. The citation was issued on June the 16th. Towards the end of June, the owner of the property did contact me and said that they were unaware of the condition of the property and that they would get it cleaned up. On July the 10th, the property was in compliance. The property, as of my last visit to the area, has been maintained. And I don't know if I can make a recommendation, but I think me and Jim talked about it and pretty much recommend that the citation be, the fine be waived. I think as soon as he got the citation and realized, he got out there and cleaned it up, and it's been maintained since then.
That's your all's decision, not a staff
I
decision.
didn't think we could waive a fine.
Well, you have in the past.
Pardon me?
You have in the past.
Okay.
We still need to go through the process. Yes or no?
Yeah.
We need to go through the process to show that there was a citation, but that we have.
Yes, right?
I don't think it's required.
Okay.
Yeah, and you know, in the past, you've held fines in abeyance while they go and clean it up. This one has been cleaned up, so I'm not sure I understand the difference between giving them more time and holding it in abeyance. And since they did clean it up, but that's your choice. I mean, if you think that we should collect the fine, you can establish that we should collect the fine, even though it's been mitigated, right?
I'd like to make a motion that this case be closed and considered complete.
I'll second the motion.
Okay, we have a second. All in favor, say aye.
Aye.
Okay, I heard that.
Just for the record, I think that's fine that the board take no action. I think that there's not anything wrong with that. There's no requirement that the office do anything to try to collect the fine that's on the citation. There's no requirement that a lien be placed, that sort of thing. So anything that you do that benefits the property owner that might be outside of the ordinance is perfectly fine.
Well, because this one's pretty much the same. So this is citation number 702-1016 Georgie Court in Crestwood, Kentucky. I'll try to run through this real quick. Fairway Enterprises LLC of 588 Peach Orchard Circle in Fisherville. This hearing was not requested. This is the general location, once again, in Lakewood Valley. This is a violation of the Oldham County Nuisance Ordinance, Section 1. The picture on the left was from May the 17th. You can see the junk and debris that was in the driveway, and the picture on the right shows the grass height, how tall that it was. I issued a notice of violation on May the 23rd. On June the 14th, I did a drive-by, a reinspection. The junk and debris had remained. The grass and vegetation had been cut at that time, but the junk and debris remained. So I did issue a citation. The citation was issued on June the 16th of 23. When I went out to deliver the citation on June the 16th, I did post it on the door, but as you can see in the picture, everything was cleaned up and the property was in compliance on the day that I actually went to issue it. So it was in violation. I wrote the citation, but the next day when I went out to deliver it, it was cleaned up. So once again, May the 17th, it was found to be in violation. May the 23rd, an NOV was issued. June the 14th, the vegetation was cut, but the junk and debris remained. On the 16th, I issued the citation, and upon posting the citation, I found that the property was in compliance. I spoke with the owners. They apologized, said they had been out of town and thought the property was being maintained. Since that time, the property has been maintained as of my last site visit. So once again, a recommendation that the case be closed with no fine due.
I make a motion that this case be closed, with no fine issued, and be considered complete.
Second.
We had a second. Okay, all in favor say aye.
Aye.
Opposed, nay. Okay.
So the next case is citations number 703, 704, 705, 706, and 707. This is for Roy's Body Shop of 2604 West Highway 146 in LaGrange. The owner of record is Roy Clifford. This hearing was not requested. This is the general area off of Highway 146, just outside of LaGrange. This is a violation of the Oldham County zoning ordinance that a sign permit shall be obtained. You all did issue a final order for this case. It was case number 23-0024. In the final order, you said that a new citation was to be issued daily if not in compliance within 14 days of 6/12 of 23. He did, also in that, you said that he had 14 days to pay the fine or place a lien on the property. He did come in and pay the fine of $150 on 6/19, so he met that part of the final order. He did not meet the final order in regards to either applying for a sign permit or having the sign removed within 14 days. So I did begin to issue daily citations. I did not start the 14 days until after the delivery of the final order to him. So here's that case. On June the 28th, which was definitely past the 14-day mark when it should have been removed, there's a picture of the sign still there. I did issue citation 703. I mailed it to the address on file and also took one to their shop and handed it to the manager on site. That fine amount was $250. On the 29th, once again, the sign was there. I mailed a citation and also took one to the shop. Once again, on one of these trips, I actually took them one of the applications for the sign permit. But once again, the sign, did not get removed. On the 30th, the sign is there. Citation 705 was issued in the amount of $400. On July the 3rd, so I did not go out there over the weekend. I drove by, the sign was still there, so I issued citation 706 in the amount of $400. July the 4th was a holiday. I was not working, so I did not go out there. On July the 5th, I drove by. The sign was still there. I issued citation 707 in the amount of $400. Again, on all citations, one was mailed and one was hand-delivered to the manager, and every time I delivered it, I asked the manager, you're going to continue to get these until it's removed. Total in on this July the 6th, the property was in compliance. The total in fines for 3, 4, 5, 6, and 7 is $1,850. Are there any questions?
Has he paid it?
No, the fines, the citations have not been paid as of today.
And it was removed on the 5th?
The
The 5th or the 6th?
Do what?
The sign was removed on the 5th or the 6th?
The sign was removed on the 6th. When I drove out there on the 6th, that morning, the sign had been removed. So if you look at the pictures, each picture is pretty much approximately the same time. I drive by that way, so on my way to work in the mornings, if the sign was there, I'd get to work, make my phone calls, and then I would go out, get a picture of the sign, go back to the office, make up the citation, and then I would take it and deliver it to him that day. So on the 6th, when I drove in to work, the sign was taken down. So when I got to work, when I went out for the day, I stopped by there, took a picture to show that the sign had been taken down. But on the 5 days, or actually I guess it was about 7, 8 days, counting the holidays and weekends, the sign was still there and it was supposed to have been removed. So I issued a citation for each day that I worked that the sign was there, like you all had requested.
And just to be clear with this, the manager was here for the original, so they heard our
They were
request.
not here.
Somebody was.
For Roy's Body Shop, no one was here for Roy's Body Shop at the last co-board hearing. They did not come.
But it was included in the final.
It was included in the final. I did issue a final order
Saying that it would happen on a daily basis.
on a daily basis,
These are the
yes.
things that would happen.
So here's the copy of the final order, if you can see it. So in the final order, the board voted to impose a fine in the amount of $150 to be paid within 14 days. After 14 days, if not paid, a lien will be placed on the property. The property owner must also comply with the following: bring the property into compliance within 14 days of 6/12/23 by removing the sign or acquiring a sign permit. If the property is not brought into compliance within 14 days, a new citation will be issued daily. And when I I mailed a copy of the final order to the address on file. I also took one to the manager, and I informed him that he would get a citation every day if he didn't get it taken care of within that 14 days. So the 14 days actually would have expired, I guess, on the 26th. And so the 27th, I didn't get a chance to get out there, so 28th. So it actually went about 16 days before I issued the first citation.
Does the board have any discussion?
When was the first day that he was given a notice of violation again?
The notice of violation, that would have been, I don't have that record because the notice of violation was issued.
When's the first time you said, hey, you're violating the ordinance board? That's the notice of violation, right?
That would be a notice of violation, which that was given to him in the previous case 2 months ago. He did receive a courtesy letter, a notice of violation.
So sometime in June.
No. Probably April.
Okay, April.
In the minutes.
So in April was when he got the first citation that you all heard 2 months ago. You all received that citation. You all held him to pay the fine, and then said if it's not removed in 14 days, you all were going to fine him daily. That was your all's final order.
So are you asking us, Adam, if you should continue to do
No,
citations?
the property is in compliance as of today, but a citation was issued, and it's a matter of he owes the $1,850 or so.
So you're asking us to consider something else?
No, if I issue a citation, I bring it. It comes to
Do you want to
you
collect?
all.
Yeah, because
I wanna
each
collect.
citation automatically comes
I
here.
can't make the motion, but
So do you want to?
Madam Chair, I'll make a motion that citations number 703, 704, 705, 706, and 707 were issued properly to the property owner.
should
Second.
be collected.
No, you're just dealing with where they
Going down
issue
the
property.
line.
Go through the procedure.
Oh, through the whole
right now.
procedure, I'm sorry. Okay,
And I seconded.
we have a second? Who seconded? Okay. Okay.
And I'll make-
All in favor, say aye.
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 Opposed, nay. Okay, motion carried. Okay,
I'll make a motion that there was a violation of the Oldham County zoning ordinance committed because the activity being conducted on there was not permitted by the uses allowed in that zone, and it was a unapproved sign on the property.
okay. We have a motion on the floor. Do I have a second?
Second.
Okay, we have a second. All in favor, say aye.
Aye.
Opposed, nay. Okay, motion carries.
I voted aye. Madam Chair, I'll make a motion that the aforementioned 5 citations totaling $1,850 even be paid within 30 days.
Okay, we have a motion on the floor.
Second.
Who seconded?
Clayton.
Thank you. Okay. We have a motion on the floor and a second. All in favor, say aye.
Aye.
Opposed, nay. Okay, motion carries.
So this is old business, some follow-ups from previous cases. The first case is case number 22-0136. This was 7410 Peachtree. This was the gentleman that had the septic tank that fell in and needed to be repaired. As of yesterday, no changes. There have been no changes. I have been able to reach the property owner with several attempts. A site visit on August the 1st, I noticed other possible violations on the property when I went there yesterday. This is a picture that nothing has been done. As you all can remember, last time he did fence it in. He talked about putting a concrete lid on it. It's still got the plywood sitting over it. It is fenced in. I will say there are some other violations, so I am going to be issuing violations for some other issues on the property. But for that case, as it stands, he still hasn't fixed it. I mean, do you all, want to go ahead and place a fine on the property? I mean, this has been going on since March.
Do we know if he made payments on a new septic tank?
I have not been able to reach him at all. I've made a couple of attempts at the door. He wasn't answer. The phone number that I have, I've called several times, and it's been at least close to a month since I've talked to him.
If I remember correctly, the last meeting you presented that he was going to put a lid on it, and that was going to be
concrete
a temporary lid, and that was going to be satisfactory from your standpoint and the health department's. Is that correct?
That's correct.
And that has not been done?
That has not been done.
Then
We withheld the fine?
Do
We
what?
withheld the fine before? Did we hold it in abeyance?
We held it in abeyance.
Okay.
So do we need to vote to release that? Because, I mean, he didn't meet our he didn't meet our, okay. I figured that would be automatic. If he didn't meet it, it just happened.
No, we need a motion.
Then I move that we no longer hold that fine in abeyance.
Okay.
second.
All in favor, say aye.
Aye.
Okay. Nay? No, okay.
Does that mean we write him a letter and tell him he has
yes, I will.
days to pay the
Yeah.
fine?
Yeah, I will.
And how many, do we have to specify the number of days?
It was a $150 fine.
Do we have to
and then-
specify how many days he has to pay it? I would recommend 7.
Okay?
Well, just remember that, when does that start? Because sometimes, Adam's got other things to do. 14 is always really good, because by the time he gets it in the mail and whatnot, and the mail delivers
So,
it,
yeah, can we do 14 days from the date that I issue the final order?
yeah.
That's good for me.
Yeah.
Your future violations, will they include a second notice of violation on this situation?
They can, yes. Yes, it will. It's going to be that and a few other issues that I'm going to address with him. It probably will not be a citation for the other things. It will be a notice of violation. And then if he doesn't address those, I will be issuing another violation, which you all will hear again. We good?
Yes, sir.
Did you all vote on this?
Yes, we did.
Okay, I missed it.
Yes, 4 said yes. Motion carried.
Okay. The next property was the case number 22-0129, 7699 Catalpa Avenue. This gentleman was here. He was the one, had quite a few things to take care of. His name was Michael. Y'all gave him 30 days. I don't know if y'all can read that, but it was, there was a lot. 2 weeks from May the 5th to have the brush removed from the roadway. 90 days to rebuild the shed, 60 days to get in contact with the owners of the vehicle and have them removed, and then to communicate with me about the debris that was behind the fence. So the 90 days has not expired yet for the rebuild of the shed. So I did speak to him just the other day. And let me read what I wrote here because I'm trying to remember. Some debris remains that needs to be moved to the burn area. There was new debris added by an unknown source. The vehicles have not been removed. Michael did request until tax time of next year for the removal of the junk that's in the rear of the yard that you all told him to get back with me on, so that he has the funds for a dumpster. He said he will chip away at it until he has the funds for a dumpster. He did inform me that he could not attend today's hearing, but he would be at the next hearing to explain the circumstances in more detail. So where in these notes where I said that more of the debris had been added, it was not by him. Apparently the tree trimmers that come through, trimming the trees and the power lines, they threw it on top of his debris pile. I have spoke to him. He is willing to move that to the burn pile and burn it all off, but he said he is going to need additional time because they piled some of it on top of his debris. I do have some pictures. So as you can see, the vehicles are still there. You can see that if you look at the debris pile on the right, you can see it's just now got the brown leaves. When I was out there the first time and saw it, it actually was still green. And I could see where they had cut it out of the trees. He did say he will get it cleaned up, and basically he's asking for an extension to get a lot more done. I thought I took a picture of the front of the house. From the front of the house, looking at the house, it does look a whole lot better. I will give him that. From the street view, looking towards the house, it does really, there's a lot of improvement. The three things that need to be done, he still has to fix the barn. The two vehicles do have to be removed. He said he can't get a hold of the owner. I did give him some options to at least get them out of the field, and ways that he could have those hauled off the property. And the debris does need to get put over there, and then he is requesting for a lot of time to get a dumpster there, but that cannot be seen from the street. It's only from the neighbor's yard. And he said he would be at the next hearing. So do y'all want to impose a fine or to give him more time until the next hearing?
Did I hear right? You said the 90 days wasn't up? Or
The
was
90
there
days
some-
for the shed is not up. That would not expire until about 3 more days. So he doesn't have a lot more time left on that, but I don't think it's going to get done. He did move the majority of the debris. There was still some left, and then some added on.
Well, I can attest that they don't take that brush away because they came and cut off me and they just dumped it in my yard. And they did it in my neighbor as well. My neighbor called and complained, and they pushed it over onto me. So I can attest that they do that.
So one of the recommendations is that possibly just wait till next month when he comes in? Is one of the suggestions you're giving us?
I would be good giving him until next month, that he shows up to the code board. That way he can discuss the circumstances in more detail. And I will have more pictures to kind of show the shape of the property. And hopefully he gets, maybe he gets the shed done or gets 1 or 2 things done before he shows up. But it's,
Madam Chair, I'll make a motion that we extend his time frame until the next meeting of the Code Enforcement Board.
I second.
Okay, we have a second.
Question? Can I ask a question about the motion?
Yes, sir.
What I hear your motion is you just give him time to remediate it by the time of the next board? Is that, okay, I understand the motion. You just want to give him
Yeah, we're
30
hoping,
more days.
we're hoping that he will
get
actually
everything
get it
cleaned
done.
up.
give him 30 days and then require him to show up to the board next.
But we know he's not going to do it and ask for 9 more months. That's 9 months away.
No, the tax time was just for getting a dumpster on site to get the junk that's behind the fence. In the final order, no time limit was given on that. Basically, it said that he was to communicate with me to come up with when he can get the junk behind the fence removed. So that is something that was not even it was discussed, but no time limit was given to him on the junk behind the fence. And he just said he needs to get a dumpster to get that junk hauled out.
And that's not as visible from the street.
It's not visible from the street at all.
And that's still a code violation.
It still is,
Behind the
yes.
fence.
Yeah,
It's still a
correct.
code violation.
Correct.
Okay. I
But
understand.
he's not asking for that right here. He is going to ask for that in the next meeting. So when he comes here next time, he's going to explain to you how much time he needs to get all that junk hauled off. Does that kind of clear up? He's asking for 30 days for the first three things: the truck, the debris, and the shed. He's asking for 30 more days for that. And then he's going to be at the next meeting to discuss how long you're willing to give him for the debris that's behind the fence.
I'd recommend that we imply to him or tell him that 9 more months is not going to be acceptable so that he can be prepared.
I can tell him that.
If you guys.
Can I get
I
back
would
to the
agree.
motion, please? And then we can tell him all the other things, okay? Because if not, we're gonna, okay, we have a motion on the floor that he has 30 days, and he is to come to the next code meeting. Is that correct? And I
Yes.
had a second already, so can I have a vote? All in favor say aye.
Aye.
Opposed, nay. Okay, motion carries.
So the next case was case 23-0086. This was 6114 Park Road. In the final order, you all did say that he had to pay the fine amount within 5 days or place a lien on the property. And then you voted for me to do a full assessment of the property for structure for any county violations and issue citations for each one within 1 week. So I did go out that way. He did stop by so I issued the final order on June the 12th. On June the 14th, he did come into the office. He paid the fine in the amount of the $150. So Joseph came into the office to pay the fine and discuss the property. He informed me that he is putting a new roof and trim was to be installed in 2 months. The brick facade was going to be fixed and general cleanup of the house within 2 months. And he was going to hire a maintenance company for the property. I did speak to him yesterday. He informed me they are hoping to start on the roof in this month and to start getting the property all cleaned up. From talking to Jim, we didn't move forward with issuing the citations on the structure itself because he did come into the office and said, look, we're going to get a new roof. Give me 2 to 3 months is basically what he said. And this was just a general update to let you all know where we stand on that property. And, if by the next co-board hearing, if he hasn't started on that, I will be issuing citations for the property.
Sounds good.
No action is needed.
No, I don't think any action is needed on this one.
I will say that having experienced roof damage from hail, that about 21 days is what they're telling me to expect to wait till I get mine replaced.
I think he's already contacted a roofer. It's just a matter of getting it done. So this is a picture of the property currently as it sits. As you can see, for the most part, it's been maintained a lot better, but the structure of the house is where we were still having some issues. And side views. Next time I'm out there, I'll get better pictures of the side. The next case is 7401 Hemlock Avenue. In the final order, you all had the fine of $150 to be paid within 14 days, or a lien was to be placed on the property, and the property was to be in compliance within 90 days of June the 7th. That 90 days has not reached yet. But as far as the final order part of having the fine paid within 14 days, he did come in on June the 21st, which met that deadline and paid the fine in the amount of $150. So I don't think there's any action on this one. This is just to give you an update that he did come in and pay it. And he still has time to get the property cleaned up. So this is another case for us. This is the one we added for the other at the beginning of the meeting. This is case 230044. This is 1407 Grandview Court. The owner on record is Wendy Summers. You all did issue a final order to reduce the number of ducks on the property to 4 within 30 days of May the 5th. At the last co-board hearing, we did close this case out because I had been receiving no complaints, and I couldn't get a count of the number of ducks. I had made several attempts over there, and I wasn't seeing any. So at that time, we did close the case due to no complaints, and we considered the property to be in compliance because I had no proof otherwise. As of this week, I have received several complaints from the neighbors about the ducks. I did ride over there today, and there's a picture.
Oh, my God.
It's not 4.
There's approximately
About
24, somewhere between 24 and 30. You all can count ducks all y'all want, but so I'm talking to Jim. Looks like we're going to be issuing a citation. My plan would be this week, issuing another citation to her. This would be a second citation. I think last time you all waived the fine or held the fine in abeyance, and we thought that it was in compliance because we had no evidence otherwise. Today I did get the evidence. It's definitely not 4 ducks. So I just wanted to give you all an update on that one. If you all, from the county standpoint, I'm just going to issue a citation and bring it to you and send it to her.
Do we need at this time to withdraw our held in abeyance?
We can't because he closed it.
We did close that case. So, but I wanted to give you all an update on it because this happened to come up today.
Oh, well.
So, and that concludes the hearing, I guess.
Okay, there being no further business?
Nope.
Anybody have any business to bring before the board? Okay, being no other business, we are closed. We are adjourned.